We're talking about case studies of defamation. We're going to be analyzing the New York Times Company versus Sullivan and Gertz versus Welch. In the defamation case of New York Times versus Sullivan, there are two parties mainly involved, which includes the New York Times and one of the three respondents elected commissioners of the city of Montgomery, Alabama, Mr. L.B. Sullivan. Sullivan believed his reputation was damaged by the New York Times publication on the fact that he is the Commissioner of Public Affairs, which means his duties consist of supervision of the Department of Cemetery, Police Department, Department of Scales, and Fire Department. Since his duties were as such, Commissioner Sullivan felt that the advertised statements published in the New York Times that presented the police actions were directed against a civil rights leader and students who participated in civil rights demonstrations. Commissioner Sullivan felt he was held as a responsible leader in the public eye based on his duties as a supervision for the police department of Montgomery, Alabama. In order for the plaintiff to prove defamation, libel action, the plaintiff must show defamation with proof of actual malice under the state law. The proof, the knowledge of statements were reckless, disregard of the truth, and of false. The U.S. Supreme Court decision was rendered Sullivan the award of $50,000 by all four individual practitioners and the New York Times Company practitioner and others of the Negroes in Alabama clergymen practitioners. The U.S. Supreme Court decision was made based on a state's power that limits the press and speech against a public official against his critics of his official conduct and gives liability for libel action and awarded damages. Gertz and Welch. In the defamation case of Welch versus Gertz, there are two parties involved. Welch, an author of a publishing magazine, American Opinion, and Elmer Gertz, a reputable attorney, representing himself as counsel of Nelson family in the civil litigation against a Chicago policeman named Nuccio, convicted for murder in the second degree. Elmer Gertz was not considered a public figure, but a private person in the case of defamation. The alleged defamatory statements about Gertz in the American Opinion article referred to him as a communist frontier, architect of a frame-up and alliances, which implied that Gertz had a criminal record and an officer in a communist organization of the National Lawyers Guild in the publication of the American article. The article implied his communist organization had planned a communist attack during the 1968 Democratic Convention on the Chicago police. Other allegations imply that Gertz was an official in the Maastricht League of Industrial Democracy, originally known as the Ecologic Socialist Society. Welch did not investigate the accuracy of these allegations against Gertz. Based on information given, the managing editor of American Opinion article trusted Welch's authenticity and accuracy as Welch upheld his author's reputation with his editorial contributions to the American Opinion. Welch's reputation as an author resulted in the managing editor of American Opinion not to make any effort to verify Welch's information being published in an article about Gertz. The allegations Welch published about Elmer Gertz greatly discredit his reputation as a lawyer. Welch harshly attacked Gertz's character, morals, and values as a citizen. Welch implied through his allegations that Gertz had other motives as representing counsel for the Nelson family. To avoid the lawsuit in this case, Welch should have made sure his allegations were accurate and substantial. Instead of conducting extensive research on the case of Richard Narco, he should have given ample amount of time to research Elmer Gertz. Virginia defamation law. Based on the Virginia defamation law, elements of claims consist of publication of an actionable statement with the requisite fault on the part of the defendant. An actionable statement must be proven as a false statement in the fact that discredits the reputation of the plaintiff, harming the plaintiff's reputation in the public or community, or causes others to disassociate with the plaintiff. Virginia defamation law upholds statements that do any of the following: attributes the plaintiff the commission of criminal offense involving moral, for which the party, if charged, is true, may not be indicted or punished, indicates that the plaintiff is infected with a contagious disease, attributes the plaintiff's unfitness to perform the duties of an office or employment of profit, or lack of integrity in the discharge of the duties of such an office or employment, or hurts the plaintiff in his or her profession, trade. Virginia defamation law protects the plaintiff if considered a limit purpose public figure. The true definition of this term can be researched on the actual malice and negligence section. In determining the factors of whether a plaintiff is a limited purpose public figure, the Virginia courts look for the plaintiff have access to channels of effective communication, whether the plaintiff voluntarily assumed a role of special prominence in a public controversy, whether the plaintiff sought to influence the resolution or outcome of a controversy, whether the controversy exists prior to the publication of the defamation statements, and whether the plaintiff retained public figure status at the time of the alleged defamation. Other organizations, individuals, and others can be determined to be private figures in Virginia defamation law as well, such as a public school teacher, a university professor, and any organization or company involved in a private and government practices. Based on the Virginia Defamation Court's laws will give liable action to any persons expressing malice and or negligence brought by public figures who are seeking compensatory damages due to defamatory statements that bring substantial danger to his or her reputation. After reviewing both cases, New York Times Company versus Sullivan and Gertz versus Welch, I have learned that as I enter my future career in the communications industry, that accurate evidence information is imperative. Having a substantial information against an individual prevent a pending defamation case. In the communications industry, a client and their representing counsel should review the consequences of defamation and be aware of how to prevent any state laws against defamation in the state they both reside in. If you want more information on both of these cases, you can go to the references shown here. Thank you for tuning in with me, and have a good evening.